Right. Can you hear me? I've unmuted.
Yes, I can hear you, Sheldon.
Yes. Can you hear me?
Thank you.
Now you can hear me. Sophie or Katya?
Yeah, you're all fine, Sheldon.
Okay, just I have one quick question. If anyone indicates they don't want it recorded, what should I say we'll do?
Don't worry about that too much, Sheldon. You're welcome to start with this session.
Yes, I can hear you, Sheldon.
Yes. Can you hear me? Now you can hear me. Sophie or Katya?
Yep, Sheldon, you're ready to go ahead.
Okay, just I have one quick question. If anyone indicates they don't want it recorded, what should I say we'll do? I didn't hear that.
Yes, we are ready, Sheldon, to go ahead. We will take care of the recording issue. It's fine. Don't worry about it.
Okay, fine.
Thank you.
So I'm waiting. Am I waiting for something now?
No, Sheldon, just begin the session now.
All right. So I need to get what was just sent to me by Surya. Let me just get this. Sorry. Hello. Right. Can you hear me? I can't tell if I'm being heard. Yeah? Is it okay? All right. Hello, and sorry for the slow start to this. This is a great pleasure to have with us Surya Deva, who's a longstanding friend of Essex, and is now with the very important working group on business and human rights that is under the auspices of the United Nations. Surya is a professor at the University of Hong Kong and has intimate knowledge of the latest developments as well as the background to the business and human rights linkage. I think it's fairly safe to say that he is one of the most influential figures in the whole area. So with great pleasure, I'd like to turn things over to Surya. We will hear from him for about 30 minutes, after which we'll welcome questions, which you can send via the question and answer window. And we're due to finish at 11:30, I think. And so the only final point is that this session is being recorded. So if you have a problem with that, you can send me a message and we'll do something about it. Thank you very much. Over to you, Surya.
Thank you very much, Sheldon, for the invitation and kind introduction. Over the years, I have learned a lot from you and other colleagues at Essex, and also the other people who are joining this webinar. So it's really a great pleasure to be having this conversation, hopefully with all of you today. I will prefer to speak in my personal academic capacity, because that would allow me to speak freely and say things that I think may be more relevant and exciting for all of you. Because the working group, of course, has a mandate, which all of you know, and I'm sure all of you are familiar with what the working group does. I'm happy to answer any questions about the working group's role as well, if there are any specific question, but I will prefer to speak mostly about my personal experience, I will say, of last 20 years in this particular field. The key argument that I would propose for your consideration is that I see considerable risk of business and human rights project or this movement becoming a new type of CSR. And I will try to explain what kind of risks are there and what we need to do to avert those risks. And I will try to present this argument in 4 parts. I'll briefly, first of all, mention the current state of the BHR project at this particular point of time in 2021. Then I will outline why do we need to rescue this BHR project, why I'm thinking that there is a risk there. And then I think the third part of my argument is that perhaps one explanation is that we do not have enough rights or rights at all when we talk about business and human rights. So we perhaps need to reinstate the idea of rights in human rights in the legal rights sense. And finally, I will conclude with what needs to change. I think some of my observations may be provocative, and I think that is perhaps intentional, and I would like to hear your feedback on those comments as well. Now, in terms of the current state of BHR project, I think it is safe to say that there is an increasing awareness all over the world, to a varying degree, of course, about business and human rights issues and standards. And there is an impressive uptake of UN guiding principles, as well as the alignment of other standards and norms with UN guiding principles. Perhaps this is unprecedented in the history of United Nations, that a document which is proposed by the special procedures, it has become so influential that it is shaping the discourse, not only the BHR field, but also in related fields. So I think that is definitely remarkable in my view. It is also very clear that human rights due diligence, HRDD, has become the new lingua franca in the BHR field. And of course, UN guiding principles are not merely about human rights due diligence, but I think if one thing that stands out, I think it has to be human rights due diligence. And I know there has been an interesting debate on this particular issue in European Journal of International Law, that whether this stands out or not. In my view, it stands out. My last point on this first issue is that BHR perhaps is no longer a field. It has become a lens. It has become an approach to analyze each and everything in the world. In fact, what is not BHR now? Because almost everything is connected to business or human rights, if not both. There is hardly anything in today's world we can do without the involvement of businesses. And of course, human rights have been very, very pervasive in a discourse term. So everything is BHR. That has an advantage, of course, but in my view, it also has a disadvantage, because if everything is BHR, then what is BHR? So I think that also raises this question. But let me now turn to why do we need to rescue the BHR project, in my view. And my experience here, my sharing here is based on my 20 years of experience in different countries. I come from India. I started in this field because of the Bhopal gas disaster. Because I got a teaching position in a city called Bhopal in India in the year 2000. So that case study, and when I moved to this law school in Bhopal, that triggered my interest in the business and human rights field. And I shifted my research interest from constitutional law and human rights generally to business and human rights. And I would like to submit for your consideration 4 points of my worry, despite all the progress that I've indicated. My first point of worry is that hardly much is changing on the ground. Despite the UN guiding principles, despite the awareness, despite the alignment, despite the scholarship, despite the advocacy, despite the campaign, despite the national action plans. I talk to human rights defenders and civil society organizations on the ground all the time. And what I see is that not much has changed for the rights holders on the ground. And I think that is my worry. We may have human rights due diligence, we may have impact assessment act processes, but in many cases, all the development projects and supply chains are going as normal. there's not much disruption to those human rights abusing projects and supply chains that I have seen in the 10 years. There are tweaks here and there, but they are not fundamental. If after the impact assessment, a significant portion of the community says that we do not want this project here, whether it is a mining project, whether it's a hydropower plant, or whether it's something else, creating a special economic zone or a processing zone. So no means nothing, no means yes. I'm not aware of many projects that have been stopped. There is delay, of course, but if you look at the large proportion of projects, and of course we need more empirical evidence, because what I'm saying is more anecdotal based on what I hear continuously from civil society and defenders on the ground, that no means yes for businesses and for the states. The attacks on human rights defenders are continuing. There is no drop in the number of those attacks. And in fact, now states are starting to label defenders and civil society organizations as anti-development, anti-national, and in some cases, terrorists. So this is my first worry, that despite all the signs of progress, what is changing for the rights holders? Perhaps not much. And I would like to add here a very catchy title of one OECD Watch report, that remedy remains rare, which is still the case in my view, despite all the progress. And I will come to some of the cases which are cited as the signs of progress in the UK or in Netherlands or in Canada or elsewhere later on. That is my first point in terms of why do we need to rescue it. My second point is that we see very weak political will on the part of the states to act. States have been part of the problem when it comes to human rights. This is not unique to business and human rights, but of course, they have been a key challenge in the BHR field as well. And I think the response of the UN Guiding Principles or the BHR field as such is polycentric governance, that let us do not rely on merely on states, but rather try a number of actors and players and leverage points to make a change. And I personally agree that this approach is definitely worth pursuing. But what I find is that even polycentric governance is failing if states do not act. So we cannot really take out and fill the state deficits by other actors all the time. And I would like to argue here that mandatory human rights due diligence legislation, the push that we see in Europe, this is a concrete example of a failure of Pillar 2. You may see that they are being inspired by UN Guiding Principles. That is one explanation of it, and I think that is true. But the part of the explanation or the other side of the story could also be that the Pillar 2 is failing on its own without any action on the part of the states. Companies are not doing what they were expected to do as part of Pillar 2. So if the states are back on the table, if the states are ultimately needed even to push polycentric governance, then are we not back to square one? That the states are still quite central to BHR. And if states do not act, then other actors have very limited role to influence. So states have to bring in due diligence legislation. States have to bring in transparency. States have to change the system of remediation. And unless those things change, the other levers of change have very limited role, it seems. So that is my second worry. So are we solving really the governance crisis then? Because we are ultimately going back to what we have seen for the last 30, 40 years. My third point is that states continue to have this mindset of incoherence and sequencing, which I will call economic development first and human rights later. And of course, I see this in the global south, the states which will think that, okay, we need to develop first, and development is vital. And we also have the discourse around right to development, of course. But can we not integrate them well? And I don't see that integration happening. And I think sustainable development goals perhaps do not achieve that integration well as well, because the human rights language is better in the SDGs as compared to MDGs. But still, even if you look at paragraph 67, where the SDG resolution talks about UN guiding principles, it is very stark reality that paragraph 67 does not use the term human rights at all. It merely talks about labor rights. So this discourse of development first, in my view, continues. Despite the UN guiding principles, despite the progress that I've highlighted. And in fact, there is a risk that SDGs may bring back the idea of corporate philanthropy and CSR back on the table. They may already be doing it, in fact. And I think we can see this climate crisis in this particular context. So states are not learning lessons. They still want to first develop and then fix the issues about environmental pollution or climate change. My fourth and the last point, why do we need to rescue this BHR project, is that perhaps, and this may be controversial, I guess, that UN guiding principles inadvertently are perhaps providing a safe harbor for businesses. If you look at the process of developing UN guiding principles, and I've written about it, the engagement with businesses and the support of businesses has been critical. And I believe they are vital stakeholders, and that support and engagement is absolutely vital. But I will argue that that support also has a drawback. And the drawback is that it was not the intention, perhaps, but UN guiding principles and the BHR discourse that we see in the last 10 years, here businesses are feeling more comfortable with the ideas and narratives that are being articulated in the mainstream. Whether it is about having a human rights journey, so every company is on a human rights journey. They can stroll on their own pace. So you don't need to fix everything tomorrow. So you can take your own time. That could be 5 years, that could be 10 years, or that may never happen. But of course, when it comes to profit, you also need to show tangible progress several times in a year. That progress need not be shown when it comes to human rights in the same manner, for instance, right? When we talk about collaboration, multi-stakeholder partnerships, constructive dialogue, all these things are in a way facilitating, which I will argue, corporate capture of the human rights language and discourse. And corporations are also capturing the UN processes and UN institutions. Unfortunately, and I know now more because I've worked inside the system now. But I wrote about it about Global Compact many, many years ago, where I have no idea of the UN system. And I was, as an outsider, had a very rosy picture of the United Nations. And I felt that UN Global Compact created that opportunity of capture. And now UN is suffering from funding crisis. And then that also creates this more temptation of unprincipled partnerships with businesses. We also have this new industry of consultants that UN guiding principles have created. And I think there is a positive and negative here. The positive is that businesses and the executive leaders, they may not fully understand what human rights are and what UN guiding principles are. So there is a role for experts. Definitely, I completely agree with that. And I think that expertise can be provided by those consultant firms, some of which are also non-for-profit, and some could be just normal business enterprises as well. But I also see a dark side of it. And the dark side is that perhaps they're selling ideas which could be problematic. To get a consultancy, to get a project, they may be selling the idea of the business case for human rights. But Pillar 2 is not based on the business case for human rights. right? So when you always try to articulate a business case for human rights, and it is not merely consultants, I have seen even UN agencies telling me multiple times that let us try to make a business case for human rights. That will be easier to convince businesses, right? So if that is the narrative, then are we really talking about BHR or are we going about CSR? Because Milton Friedman also said this, that if respecting human rights and doing all these good things in society is going to increase profit, let us do it, but don't call it CSR then, right? Business can do many things to increase profit. So if human rights end up becoming merely a tool to enhance the profit of businesses, then are we really talking about these human rights responsibilities, which should be non-negotiable as a normative standard? With this, let me move on to the third part of my argument, which is reinstating rights. What does it mean? So I have kind of highlighted the crisis in my view, my fears, which may be unfounded perhaps, and I would like to hear more from you. But my experience of last 2 decades tell me that I'm not feeling very optimistic of the progress that we have made in the last 20 years. And I think these are some of the red flags that I wanted to put on the table. And I think one explanation for these red flags, in my view, could be that we do not have enough rights and rights-based discourse in the field of business and human rights. We need to perhaps reinstate rights. And again, I have 4 points for your consideration. My first point is that if you look at Pillar 2, it mentions International Bill of Rights and ILO Declaration of Fundamental Principles, but that is not a basis of the basis of this responsibility of business. The responsibility of business to respect human rights is grounded in a social expectation. And social norms, ethical norms do play an important role, but they do not replace what are rights and rights-based approaches. So there could be a complementary relationship between the two. But I think we need to ensure that the language of rights is critical, because when you say rights, it entails duties and obligations. It triggers in the idea of remedies. And I think I don't see that happening much. Of course, we're talking about now mandatory human rights due diligence, which has a potential in my view, but it could also backfire in a big way if we do not get it right. And that is also part of my worry, which I can mention perhaps when we start talking about these issues. My second point is that are we taking rights and rights holders seriously enough? And perhaps not. We need to take rights holders more seriously. And let me take one example here. So businesses are expected to do human rights due diligence as part of Pillar 2. But should it not be done by the rights holders? So Pillar 2, everyone talks about Pillar 2 is about businesses. I see Pillar 2 differently. Of course, it is about businesses. But to me, Pillar 2 is about others. It is about the rights holders. So rather than businesses doing it or businesses outsourcing the human rights due diligence process, it should be the rights holders who should be deciding what is good for them and how their rights are being impacted and how the project should change or not take place at all, right? And if they say no to a particular project, that should be the end of it. The project should not go ahead. So here what happens is, in a typical situation, that we have some civil servant sitting in the capital of a country, talking to some executives of a company, sitting in a 5-star hotel, deciding what kind of a development we want and how many thousand of indigenous peoples we want to displace without their consent or with symbolic consultation process. That is what we're talking about in the current system. So the due diligence and impact assessment is merely a legitimacy exercise. My third point is that we need to go beyond begging about rights. In the current situation, what I see is that states are saying, let us do something which is acceptable to businesses. Even UN guiding principles are based on this idea that we cannot propose anything which is not acceptable to businesses. So if everything is at the mercy of businesses and business lobbying, and without their consent and without businesses coming on board, we cannot move forward. Are we really talking about rights? Or is it something else? And my last point is that corporate accountability. And here I would like to bring that, of course, we have made some progress in terms of cases in the UK, in particular, like Vedanta, Akpabi, and all that. Cases also in the Netherlands and Canada and elsewhere in some other jurisdictions. So that looks promising, and I would agree there is some promise there. But those cases, most of them are about jurisdiction. They are not concluding on merits that the parent company has breached a duty of care so far, right? So I think that is, and again, how many cases can be brought before the courts in UK? How many cases will be successful like this? Lee and Day has done a tremendous job, but how many victims they can represent, right? And what happens ultimately? Vedanta settles the case outside the court. The agreement is confidential, but what we know is that they are not admitting the liability. And here I would like to contrast with the Bhopal settlement. So Bhopal gas disaster took place in 1984. A settlement was reached in 1989. And the company gave money, but it expressly said that this money is given without admitting any liability. Fast forward 2021, Vedanta settles the case, but then they don't admit the liability. So are we making enough progress in those 30 plus years where businesses are throwing some money simply because they have the money and they are not owning up? They're not even willing to offer a public, sincere apology to the victims that we made a mistake. We are sorry for that and we will not repeat it in the future. They are not willing to even do that. What kind of accountability and justice are we talking about here? I still remember there was a victim of this gas disaster in Pakistan. She came to the UN forum, I think it was 2018. And I can't forget her words. And I will say it in Hindi first because she was speaking in Urdu. She said that paisa to mila par nyay nahi mila, justice nahi mili. So, and I will repeat in English now. So she said, we got the money, but not justice. So even the victim, the mother, she was the mother of the victim, in fact, because her son died. So she said that money compensation does not equals to justice. So what companies are giving in settlements, this is not justice. This is merely a partial remedy at best. Now, final 5 minutes, I guess. I still have a couple of 5 minutes. Sheldon, if I'm getting the time right?
Yeah, that's fine.
Thank you. So in the final 5 minutes, let me outline what needs to change. What needs to change if we have to save this BHR project from becoming a new kind of CSR? First of all, we need to ensure that we have enforceable obligations of businesses. And here the role of not only human rights law, but non-human rights law become critical. And several colleagues at ASEX like Tara and Anil and others, they have articulated the role of international investment agreements, for instance, and I'm writing a report on that for the working group. So I think that is quite critical in my view, because investment agreements, in my view, reflect incoherence, irresponsibility, and I think we need to fix it. They also reflect imbalance. So I would say 3 I's. Incoherence, imbalance, and irresponsibility. And I think we need to address this. I'm perfectly fine with soft responsibilities of businesses if the investment agreements also become soft and not legally binding. My difficulty is we have the battle amongst unequals. The rights of investors are not soft. The remedies that they can seek is not soft. But when it comes to victims, everything is soft. So either we can have soft versus soft, or we can have a battle between hard versus hard. And of course, there will be competing and conflicting issues, but I think it would be a fight amongst equals. Now it is not a fight amongst equals in my view. And of course, I'm not even going and making this argument that the human rights should prevail over trade and investment. Of course, as a human rights scholar, I would make that argument, but let us even not make that argument of supremacy of human rights. Let us treat everything equal. But even if we treat everything equal, that equality is not there. My second suggestion is that we need to draw some red lines. For the time being, it looks like to me that everything is perfectly fine as long as you do human rights due diligence the way you like it. This is problematic. For instance, can a tobacco company ever comply with UN guiding principles? Even if it addresses child labor from its supply chains and other issues, can it ever respect right to health? And in my view, it cannot. So we need to draw a red line in those situations. Can companies that are operating in close proximity with the military junta in Myanmar at this particular point of time, they respect human rights at this particular point of time? I have my serious doubts. And there are other examples from the world of similar nature. So I think we need to draw these red lines. My third point is that we should make abusing human rights by business a costly business. Abusing human rights is not a costly business for companies at this particular point of time, unfortunately. But we should make it a costly business so that they know that it is better to respect human rights rather than violate and ignore human rights. And that would require a range of incentives, blacklisting, sanctions, and accountability at national, regional, and international level. That may not happen. But my role is not to articulate what is politically feasible and what is acceptable to businesses. My role is to show the mirror and say what is needed for the rights holders. Political feasibility is a separate term. My fourth point is that we should confront what I will regard the structures of irresponsibility and inequality. We are assuming, it seems, that human rights due diligence can fix human rights abuses in the global supply chains. I have my doubts if it can do that ever. So the question we should be asking is that is it at all possible to have such complex and globally interconnected supply chains which are free from human rights abuses? And if not, then this idea of complex supply chains must be dismantled. Now, if you look at the evolution, we had the parent subsidiary model, then we got into the supply chain model, then we are moving on to the model of the gig economy. Now, law is lagging behind. Law has not been able to fix this issue of parent company accountability yet. Companies moved on to the supply chains. We are still struggling. And we are still struggling with these two, and the companies are creating the gig economy model, right? There's an interesting recent judgment from the UK Supreme Court, but I think we need much more than that to prevent those particular situations. If you look at the extent of inequality that we are witnessing, this is blatant and obscene in my view that we are witnessing. So we have the chief executive officers of companies, and they earn more than 500 times of the salary of a typical employee in the company. Unless we fix this, I don't think we can make fundamental changes in the structures of power. And I think that's where I think we need to articulate a more ambitious, more rights-based approaches to BHR. My last 2 points are that we need to create more democratic corporations. I think there is a lot of narrative nowadays about reorienting the purpose of corporations. And I agree we need to reorient. But my fear is that even this idea of reorienting the purpose of corporations may be captured by businesses. If you look at the letters that are being issued by BlackRock chief executive every year, there's a lot of good things there. But if you look at the behavior of BlackRock as an investor, they don't match. If you look at the 2019 initiative redefining the purpose of corporations in the US, and you look at their response during the COVID time, they don't match. So this idea of redefining the purpose of corporations can again be captured by businesses. So what we need to do is we need to extend the right to information and transparency to companies. So unless there are some narrow exceptions of confidential information and all that, people should be able to seek information from businesses because they are governing all of us all the time, businesses, not merely states. We also need to have our voices in the board of directors. So non-shareholders must be sitting in the board of directors when those decisions are taken by businesses about anything, whether these are the policies about race, gender, or certain projects, or deciding who should get paid how much. Because those policies have a clear implications for the rights and rights holders. And my last point is, which is perhaps people are talking about it. I mean, there's a lot of narratives now. Let us create a stakeholder capitalism or some other different kind of capitalism. But I have my sincere doubts that capitalism can be reformed enough to deal with the governance challenges that we're talking about. Perhaps we need to create a new system of governance and economy, which is bottom up, which has small companies which are pursuing the idea of inclusive and sustainable development. Thank you very much. I will stop here and I look forward to hearing from you, your comments, questions, and disagreements potentially, if you have those as well. So thank you very much, Sheldon and Essex colleagues, once again for inviting me. I wish we were there in person, but still I'm glad that I'm able to do that. And of course, virtually means that it is good for the climate. Thank you very much once again. I'll pause here for now. Thank you.
Many thanks. Can you hear me? Many thanks, Surya, for a comprehensive, well-articulated, and very relevant set of remarks. I think, while people are putting together their questions, I just thought I would add one observation, which is that one of the things we learn about human rights, when you look at them generally, is that they have a special weight. They are different from other rights, partially because they increase what has to be shown if you're going to have a reason for overriding the right. So if you have a right to free speech, for example, the countervailing interest in stopping a demonstration has to show that there's real damage that's going to be done to give you a reason, unlike normal rights. Now that really applies in the Business and Human Rights Fund, and I think possibly would help to understand the frustrations that Surya is describing. Because very often when we find gestures made toward human rights, or indeed good faith commitments, this issue of their weight is ignored. You tend to put, understandably, but I think in this way dangerously, financial purposes ahead of the rights, such that if there have to be compromises, the aim is to produce least damage to the business interest, even though you recognize the human right that's at stake. And that is it's a weakening of what human rights can produce, because the reasoning is meant to be the opposite. Look for what will do the least damage to the human right, and the process allow business purposes to proceed. And I think the only other thing I'd note is that part of this frustration I think, is due to the fact that actually courts rarely actually bring human rights right into the middle of their remedies that they give. Take for example, the recent cases in the UK of Pabi and Vedanta. Plenty of discussion about duty of care, although a lot of it is not directly binding, but certainly there. But very little about human rights and what difference they would make in a tort claim of negligence were they to be invoked. And I think that we have to strengthen. So we have to strengthen the special weight to be accorded to a right and the special relevance they've got in areas of law that are not often accommodating to those rights. So can we look at any questions that you might have if you click into your Q&A? And I'm going to now rely on my help from Sophie and Katya.
Hi, Sheldon. I'm actually here to help with the Q&A, if that's okay.
Excellent. So, Anil.
Thanks so much for your remarks.
So, all right, over to Anil.
So shall I go on with the questions? Thank you, Surya, for your remarks and Sheldon for your reflections. So I'm gonna look at the Q&A, and we have a question from Robert McCorkadale. So let's start with that. He says, innovative and thoughtful ideas as always, Surya. What is your view on the Swiss vote on RBI? Is it a reassertion of the public against corporate capture, which narrowly failed?
Yes, I think I agree with that. And I think that happened because the Swiss system allows public to mobilize in this particular manner to amend the constitution, which is not possible in most of the other countries. But I think that was remarkable in my view. And in fact, if I have to put my money in anything, let us say UN agencies, states, businesses, others, I will put my money, if I have to put at one place, I'll put my money on people. So whether you see those people on the streets in Myanmar or elsewhere in India, or they were in Hong Kong or elsewhere in the world, or they voted in Switzerland. So I think that is, in my view, the future of human rights. And I think if that fails, then I think we are really doomed. So my only hope is people like all of us, future generation. And I think that is where I always say that the role of the teachers like us is beyond teaching. We need to inspire and create more of us who can believe and fight for the value of rule of law and human rights and democracy, despite all the challenges. So yes, that was a good example, Robert. But I think we need to see more of that, because that failed narrowly, as you mentioned, but hopefully people should build on that. And I think if you look at even mandatory due diligence in European Union or Europe in different European countries, if you take out civil society advocacy, there's nothing. They have been pushed, right? States have been pushed to do that. And I think the same applies to the treaty process. If you take out the treaty alliance, that the process might have failed for now. So I think the civil society actors and people on the street are definitely key players in my view.
Thank you, Surya. I'm going to read the next question. It's from Varsha Iyengar. I'm sorry if I mispronounce your name. Given that most research, scholarship, policy initiatives, and funding for BHR is situated in universities, organizations in Western countries, and right holders are mostly situated in the global South, do you think this gap is one of the contributing factors for lack of implementation of BHR goals? A lawyer from Bangalore.
Absolutely, I think that is right on the spot, and I will add that in the BHR field, the global South has become mostly a recipient. So the ideas are being articulated by the global North scholars, and we are receiving those ideas and implementing them. Are those ideas suitable? Let us say informal economy. I give a concrete example. how much are we talking about the informal economy, which is a big factor in the global south? It is there in the global north as well, but global south, you cannot think of an economy without the informal sector. How much UN guiding principles or OECD guidelines are addressing this elephant? So I would say that if the BHR has to succeed globally, the global south players, the students, lawyers, and activists and trade unions, they have to articulate what is needed, not merely receive from the global north what may be good for us. And I think the third world critique of international law, third world Twiley scholarship also has a role to play in my view here. Thank you. I hope that answers the question partly.
Thank you, Surya. Okay, I'm going to move to the next question, which is from Thomas Morachovich, who's a PhD candidate at the Graduate Institute. He really agrees with many of your criticisms in the area, Surya. Where I would respectfully push back a bit is the criticism of polycentric governance. I think a major positive outcome of polycentricity is the clarification of UNGP norms through a dialectical process between the various initiatives, which are then used as relevant interpretations in binding instruments, such as the draft EU mandatory due diligence regulation, which takes a lot of inspiration from interpretations of HRDD produced by the OECD. So he thinks that such authoritative interpretations reduce space for corporations to only engage in cosmetic compliance. I'll just leave that for you to comment if you wish to, Surya.
Yeah. No, I think, look, don't get me wrong. So I don't dismiss the value of polycentric governance. I'm not suggesting that. But what I'm suggesting is, and I still believe in that even in polycentric governance, states are key. So we need to recover the state. The deficits in the governance that are coming from states, they cannot be filled by non-state actors. Let me put it this way. So in addition to relying on polycentric governance and other actors, we also need to, at the same time, try to recover the state and fill those democratic deficits. Otherwise, I have my serious doubts that, because why are we talking about mandatory due diligence? Why do we need it if we already have Pillar 2? Let us just don't do anything else. Pillar 2 in itself should be sufficient, right? Because if you look at Pillar 1, in fact, it does not talk about that states should do mandatory due diligence. It does not talk about. Pillar 1 does not talk about it expressly. It merely mentions that briefly at a couple of places in the context of specific situations of state-owned enterprises or when businesses are operating in a conflict zone. In fact, I'm writing a paper now, which will be out in June, and that is about this interface between the soft social norm of Pillar 2 and the legalization. So I think I will stop here for now. Thank you.
Thank you, Surya. I have actually two questions that I think we can take together. They're quite related. One of them is from Caroline Sloan, and the other one is from Jenny Duncan, who's one of our LLM students, one of our MA students this year, who's taking business and human rights. So Caroline's asking if there is corporate capture of the BHR discourse and subsequent, how can the power that allows that capture be restrained? And Jenny is asking, how can we stop the language of human rights being manipulated by corporations as a marketing ploy? Difficult questions.
Yeah, I think we need to do many things. One thing which we can do is principled engagement with businesses. If the engagement is pragmatic, which becomes problematic, in my view. So it has to be based on the idea of human rights. I give a very concrete example. Many companies, even in 2020 and 2021, tell me in private, they are not comfortable with the language of human rights. 10 years down the line, endorsing UN guiding principles, these companies are telling me, let us use sustainability. it is better. That is something we must resist, because that is where this corporate capture of the narratives is starting, and they're diluting the idea based on rights, in my view. So I think all of us have a role to play in developing counter narratives, in recovering the rights and the. I mean, this is very similar to the fake language. Sorry, not fake language. The fake news discourse that erupted during the Trump era as the presidents. Now, the difficulty with this fake news is that Trump can use it, and even if there is not a fake news, everyone can say this is a fake news, right? So that is the difficulty. So we have these narratives now, which are very powerfully being articulated by business actors and business associations. And if we do not counter and expose those narratives and the hollowness of those narratives, then we are falling into a trap. So there's a role for trade unions, there's a role for civil society, there's a role for actors, there's a role for UN agencies. Because UN agencies are also falling into this trap of this partnership with the private sector. Thank you. I'll stop here.
Okay, thank you, Surya. We have a question from David Karp. He's enjoyed the talk. He's asking, is there anything different about your approach to BHR as compared to the 1990s solution to the problem of how best to realize socioeconomic rights? For instance, the 1997 Maastricht guidelines, legalization, greater enforceability, etc. Has the 1990s legalization approach to ESC rights worked? And if not, why should we expect it to work today for BHR?
I think these are difficult questions, David. And but what I would say is that what I'm articulating now is providing rights the mainstream role, right? Because rights have not been mainstreamed, in my view, in the business and human rights discourse. They were not mainstreamed in the past. Whenever there was an attempt to mainstream that, there was resistance from states as well as business interests. But the question I would like to pose for everyone consideration is that why these battles have to be state-centric? If we are really talking about polycentric governance, should we not be articulating those obligations without the states and without UN agencies, right? And if we can articulate those obligations, then we negotiate with businesses based on those obligations. So if states cannot support rights, if businesses cannot support rights, and if we really believe in polycentric governance, then I think we have to take the ownership here, which we are not doing in my view. So my difficulty is that we are picking and choosing when we rely on polycentric governance. For instance, UN guiding principles, right? There's a tremendous amount of focus of their unanimous endorsement by the Human Rights Council. Both words, unanimous and endorsement by the Council. So they are deriving their legitimacy from the UN process, right? At the same time, they're trying to articulate that it is not a state-based approach, right? Alone. So I see those contradictions. So what I'm articulating here is a more ambitious but politically infeasible thing. And I'm not proposing this in lieu of what we have. I'm proposing it in addition to what we have, so that after 20 years from now, we don't talk about creating something else than BHR, because we have been talking about these issues for the last 50 years. Yesterday, I had a conversation with colleagues in a different setting. And the question that we were discussing are the questions that we were discussing 10 years back or 20 years back, that should businesses be withdrawing from Myanmar? So that question is being debated now in 2021, but that was the question about Unicol case, mid-1990s. How much progress are we making? That is my worry. That is my frustration. So I may not have the solutions, but I think I need to expose these red flags that I see. Thank you.
Okay, thank you, Surya. I think we're going to be running out of time, but I have two questions here, which I think are quite interesting. One of them is about the idea of using arbitration in the BHR context. This is from Antoine Dual. Building on the Bangladesh Accord experience, if you think it could be useful, how would you structure such an arbitration process?
Before I answer the question, I thought we still have half an hour, no?
Yeah.
Oh, we might. Okay, sorry. I thought this was finishing at 11:30. I'm wrong.
No, I'm happy to
12.
finish
So,
early,
yeah.
but I was told to understand
we
that
do-
it is
we
until
do.
12 noon
Surya is right.
UK time.
Yeah, you are right.
Okay, so arbitration. I mean, I will have say that arbitration can be useful. I mean, there are issues with arbitration, of course. Can it be a good system to resolve public rights issues? Let me put it this way. And I think I would like here to go back to what Sheldon was saying, that UK courts are not using human rights standards and language in the tort litigation, because tort litigation is a private wrong litigation. And because it is a private wrong litigation, it becomes easier to justify those opaque private settlements with companies. But if there is a public wrong at stake, then merely a settlement with the parties is not enough. So I think there are those questions that whether arbitration as a process in itself is good enough to resolve all the public wrongs or all the human rights abused by businesses. So I think that is my first point. It may work in certain cases, but then we will need to ensure that arbitration is fast, it is enforceable, the imbalance of power is addressed, and it is not expensive, because arbitration is part of ADR, right? So if in arbitration, we are inheriting the same difficulties as in the court system, expensive, not enforceable, imbalance of power and all those issues, then what is the point? So and I think that is my difficulty with the Hague rules, for instance. So Hague rules, interesting project, but they conflate two things. They conflate the possibility of rights holders taking the company to arbitration with a supplier and a company doing arbitration. We cannot equate company to company arbitration with company to rights holders arbitration. Many of these rights holders don't even speak English language in which the arbitration may be conducted. They don't even know what their rights are, right? So unless we have people like Anil and Tara pro bono advising them, because their salary is paid by the World Bank for the next 10 years, then who will fix this imbalance of power in arbitration? So I think that is my struggle. Thank you.
Thank you, Surya. I do agree with that observation. I have my own doubts about arbitration's use in BHR disputes. We have a question from Colin Moore, who's a colleague of ours at Essex, and he's asking whether more information transparency will be enough to change the profit-oriented mindset of company directors without more specific regulation governing corporate decision-making.
No, I think a simple answer is no. Information transparency is one of the tools. It is a starting point. We need it. But it will not be enough ever. It was not enough. I mean, if you look at the research, for instance, about the UK's Modern Slavery Act that has come out, it shows that merely disclosure of these statements about due diligence does not really change anything. So this is, I would say, the deception. So if states continue to pretend, they say slavery. Slavery, I hope, is serious, right? Merely saying it modern does not make it less serious in my view. Slavery is serious. And if the regulatory response from states to modern slavery is that you merely disclose the information on the website, I think that is really shameful in my view. So what will happen to less serious human rights abuses? If that is the response UK and Australia are offering, right? And I think that is also my red flag about the mandatory human rights due diligence emerging in places in Europe, or the European Commission proposal. Yet to see how it will play out. So if it is not robust enough, I will say this could be regressive. This could backfire for the rights holders, because companies could then tick the boxes easily and say, oh, they have complied with these legal requirements and they are not liable. So I think that is something we need to be very, very careful, in my view. So I think going back to the transparency question, I think that is absolutely needed. But sometimes, how much information I can read? Let us say we have these 50 million companies, or forget about 50 million. Let us say we have 80,000 or 100,000 multinational companies. They start disclosing information every year or every month about their human rights policies. How many of us are going to read those documents? And what if they insert those 3 relevant paragraphs for us in a 140 annual report, which takes 5 minutes to download in the global south? So the internet speed is not the same everywhere, minded, right? So that glossy annual report of a company may take ages to download. And then you have to find those 2 paragraphs in that 140-page document. So that is about transparency, again, being hijacked by the corporations. So transparency is a good idea, but if you use that narrative to capture it, and that is backfiring again. Sorry, I'm being very pessimistic, but I think that was my job, because I want to show a mirror to people in the BHR community who are, in my view, in a celebratory mode, that we are achieving so much. So we feel good about it. So I want to show the mirror that yes, those are legitimate progresses we are making, but those are tiny baby steps if you compare it in the last 50 years of a struggle.
Thank you, Surya. We have a question about the draft treaty in the chat. I'll read that because I think it's really interesting. It's from Nicholas Kang. I can't read the rest of the surname. From the current direction of the draft treaty, it does not seem to address the main points you raised today. If so, do you see a real hope for the treaty to bring any changes on the ground?
First of all, we don't know whether the treaty will ever be negotiated, ever be concluded, let me put it there. And if it is, let us say, concluded, how many states will ratify and all that? So there are those legitimate questions. I consider treaty as one of the tools in the regulatory ecosystem that we need. Or perhaps we need multiple treaties, right? It's not perhaps one treaty. So I see that UN guiding principles are, let me say, not as ambitious, but similar to UDHR. And then we need to build binding instruments at national, regional, and international levels to impose and enforce those obligations. So this treaty alone will not fix everything, but we need it. That may change something. I think we should not expect too much out of it, but we still need it. How much we can push the agenda is yet to be seen. For instance, ideally, I personally would like the treaty to impose direct obligations on businesses, because that is what polycentric governance should do, right? That the treaty imposes those obligations under international law on companies directly. And then those obligations can be enforced and implemented in a dynamic manner, not only by governments, but also by non-state actors like us. Because we can take that treaty as an instrument to negotiate directly with a company. Trade unions can show this is a treaty, this imposes obligations on you. Let us negotiate this agreement in the supply chain, keeping this treaty in mind. So that would be the real game changer for me. I think the international law has to evolve, in my view. Whether it will evolve, I have doubts, but in my view, that's where we should be going.
Okay, thank you, Surya. We have a question from Cristina Blanco, and it's on indigenous peoples' rights. She says one of the main historical claims of indigenous leaders worldwide is the enforcement of indigenous peoples' right to self-determination, recognized in the UN Declaration, in order to be able to freely define their own views on development, which not necessarily coincide with the SDGs. Do you think that putting this right in a more protagonist place in the discussions could contribute to the contest, the no means yes logic we see in practice?
Yes, I think that would be really really vital. So, but again, look at this is a good question for me to give another example. If you look at UN guiding principles, or if you look at the OECD guidelines, or look at other standards, right? How much focus they have given to FPIC, free, prior, and informed consent. And mind it, it is not consultation, it is consent. There's a difference between the two, right? So the question of consent, which is bottom up and self-determination, is very vital in my view. But that narrative is also being captured, because consultation in practice is becoming, consent in practice is becoming merely consultation. And then what is happening in practice is that businesses, not every company, of course, but some businesses are adopting a policy of divide and rule. So some communities may be willing to say yes, but some communities are saying no. And then companies exploit this division rather than building a consensus and obtain a consent which is really meaningful, or even a consultation which is meaningful. So I think putting self-determination and FPIC should be part of this, developing a counter narrative of the power of rights, that Sheldon highlighted, the weight of rights, that is that. So we need to bring in the Dawkins idea of taking rights seriously, Sheldon, right? So I still believe that we are not taking rights seriously in the BHR discourse. And people argue that why do we call it BHR? Why should it not be human rights and business? Are we putting business first unintentionally? And I think we need to question each of these assumptions. And I would say that global South scholars need to do more of that. Or even the scholars who are based in the global North, who understand and can relate with the experience of the global South, can do that as well. So I don't want to divide the scholars in this artificial compartment. But my point is that the experiences from the global South must be informing what we are articulating as solutions.
And I just had a small point to what you just said. Going back to the question of free, prior, and informed consent, you refer, and rightly so, to issues about indigenous peoples and their communities, etc. Very important. But alongside this, another area that many of us are familiar with is the need for obtaining consent in ordinary management of your personal data by companies, by these enormous economic and political forces. And that, it seems to me, is something that calls for a comprehensive understanding of consent in these areas that I think is bound to happen, because we've got a legal instrument in the data protection regulation that's pushing people to think more about this.
Thank you, Sheldon. I think there's actually a question in the Q&A that really relates to the question of data and technology. So I'm going to ask that, and you can both obviously reflect on it. It's from an anonymous participant. There seems in the BHR discourse to be a focus on some areas, garment sector, supply chains, but not the same amount of attention to, for instance, technology and BHR, even though it's an area which has a business model which possibly cannot be in line with rights. Can the BHR discourse look at the business models which undermine rights, such as the right to privacy in the tech sector? Surya, do you want to go ahead first?
Sheldon, do you want to go first? Sheldon, or?
Go ahead.
Okay. Feel free to jump in later. But yes, I agree with this, that the BHR discourse is kind of, some issues become, let us say, the favorite topics the darling of the PHR. You know, they keep on changing, right? So mandatory due diligence, for instance, is the hot topic now. So that keeps on changing. Sometimes it could be human rights defenders, sometimes it could be something else. Climate change may become. But I agree that we have not been able to pay adequate attention to all the key challenges at the same time. But perhaps the challenges are too many. So there are too many issues to fix, and then we need to start with something. So sometimes then you start with the government sector or some other sectors which are so live there, right? I think there is a greater attention being given to technology issues now. I think even at Essex, there is an excellent project. I don't know if the colleague, forgetting her name, McGregor, right?
Lorna McGregor.
Lorna, yes, thank you. Lorna she was leading that project there. The Office of the High Commissioner has started what they call the BTEC project. So there are some momentum, developing now to give great attention to technology issues. But I think this is definitely going to become more significant in future in ways which we cannot even think of. Let me give one example. Let us say in a garment factory in Bangladesh, we have 10,000 workers. And in 10 years' time, instead of 10,000 workers, that job can be done by 50 robots.
Yeah.
Then that company would be much better placed because there is no child labor. There is no sexual harassment fear. At least as of now, robots are unlikely to file a case of harassment, but in future they might. That's my position, that we might need to impose obligations on robots if they become autonomous and give them rights as well. But let's don't go there. That is a topic for another debate, I guess. So that may happen, and if that happens, though, 10,000 people have a right to work, but there is no work. And will this company that created those autonomous robots, or the companies selling those garments somewhere at a very high price, which hired or bought those robots, is going to be responsible in those situations? And of course, an argument could be made, oh, this is an impact. This is an adverse. In fact, David Birchall, who used to be my former PhD student, he has argued that there should be this impact extensive interpretation of the word impact and the UN guiding principles, and this is an impact, and that's why they should address it. But can we really go that far? I have my doubts, because if we go that far, then I would say businesses cannot do due diligence at all, because it becomes so cumbersome and difficult and expensive to do. They have to stop forgetting. They have to simply forget about making money. They have to just focus on doing due diligence if we accept that wide interpretation of impact, because everything they do has an impact somewhere on human rights. Sheldon, I don't know if you want to add something.
Right. Just one remark to add to the interesting observations by Surya. I think we have to be clear that there are two levels at which this is operating in terms of technology. Technology as a matter of practice, in introducing machinery, computing, etc., is becoming more and more integrated, as we well know. So if you're trying to track who's responsible for the human rights abuse coming from a particular type of data management, for example, it actually is very difficult to put your finger very often on a particular stage in which this product emerged. And that means that we really have to start looking at corporations as wholes and not separate entities related to each other as by corporate codes. And that's exactly what is missing, it seems to me, because alongside the integration of technology among different actors, you have the fragmentation of those actors themselves, in which the classic doctrines of corporate law, for example, see there's a clear difference between the parent company and the subsidiary. And responsibility is divided in that way. If you want to go after the subsidiary or the parent, you can't do it because the subsidiary did the wrong. So integrating the remedies should go alongside with the integration of technology in ways that I think will be very important for the business and human rights agenda.
Thank you, Sheldon, and thank you, Surya. Our next question is from Ihor Konopka, and he or she is asking, why do you think BHR is turning into lens approach, which may be used to anything? And if it a case, does it mean BHR evolves but stay different, separate from CSR, or is it an evidence showing that BHR is losing its weight, so not a field anymore?
I think these are perhaps parallel developments. So I see. Recently, I wrote a chapter in a handbook on human rights and business, and I tried to see the evolution from business or human rights era to the era of business and human rights, which is currently we have, to the business of human rights. And that business of human rights is something that I try to unpack today in terms of the corporate capture of narratives and everything on those lines. So that is the dark side, where the business and human rights may turn into the business of human rights. And I think that is what I wanted to alert all of us, that those dangers are very, very real. Now, in terms of CSR, I feel that CSR is not going to die, unfortunately, or fortunately for some. So I think CSR and BHR are going to continue in parallel with some overlaps, with some divergences. And when I say it is BHR becoming a lens, then I say it is more like a way of thinking about the role of business in society. Because everything is BHR, then BHR is more than a field. Because if it is a field, then it cannot cover everything, right, as a field. Because if BHR is everything, then it is no longer a field, right? So I would say BHR will remain a field, and CSR and business ethics will remain field, and there will be parallel discourses going on. But BHR may also has the potential of becoming a lens to approach how the interaction of, let us say, individuals, rights, society, and state.
Surya, there is a relevant also question from Rose Kimoto, who's asking, how can BHR survive the onslaught by sustainability and ESG? Would you like to comment on that as well?
I think it is linked to what I mentioned earlier about SDGs. So SDGs provide a window for BHR that you can push the BHR agenda through SDGs. But SDGs also present a danger, a risk to undermine BHR, and going back to the idea of philanthropy and CSR. And I think the same applies to sustainability. We have been talking about sustainable development, and now more recently sustainability, for many, many decades. This is not a new concept by any means. But the difficulty is that in most of the times, it is about development with a sprinkle of sustainability. There is no fundamental understanding and conceptualization of sustainability. I will give one example. We are talking about climate change, and that's why battery-operated vehicles are becoming very popular. But my submission is that we should not be going towards battery-operated cars. We need to go towards bikes, not to cars. Bikes are better. They're better for climate. They're better for health. They're better that even if there's an accident, the injury is less serious. So wherever the bikes are possible, we need to go back to the bikes, not to the battery-operated cars. Because by going for battery-operated cars, we are creating another challenge for future. Why? Because batteries need minerals. For minerals, you need to go to the extraction. Where do you go? Where the tribal people are living, indigenous people are living, or you go to the oceans, right? Now, and then you worry about the child labor issues, you worry about the conflict minerals. So we are fixing one challenge and we are creating another challenge. That is the problem we have with the sustainability discourse. Thank you.
Thank you, Surya. I do like the idea of going back to bikes rather than going to electric cars. As an owner of an electric car, I'm just, I started questioning our choice. Okay,
No, but
so
I mean, I think we should not, I don't want to suggest that cars are absolutely bad. Sometimes they are needed, right?
yeah, I agree.
Yes, but I mean, if when one can manage without cars, like when I used to be living in the city of Bhopal in India, we had a car. But when I live in Hong Kong, I don't have a car. Though I have more economic capacity to afford a car now because I don't need it, right? So I think it should also be based on the needs. So if I can manage with alternatives, I should.
That's absolutely right. Thank you. So Colin Moore, our colleague, has a follow-up question to the question he asked about fundamental change in corporate law. And he's asking whether the problem starts with the education that directors receive in business schools. And this is a topic that does come up in the BHR discourse. What do you think?
Oh, absolutely, yes. The answer is unqualified yes. I teach a course on business and human rights like many of you may be teaching. So when law students come to my class in year 3 of their LLB or JD in the final year, their minds are already polluted. They have been polluted by corporate law, which sells them the idea of profit maximization and shareholder primacy and so on and so forth, and directors having a duty towards shareholders. So I think we need to definitely reorient the whole idea of training the future leaders. But I will say not merely business leaders, also lawyers. Because most of the things businesses are doing wrong in today's time are on the advice of lawyers like us. We tell them how to bypass and create complex corporate structures so that the veil could not be pierced. I'm sure corporate lawyers are now telling businesses how to overcome Vedanta and Okpavi. Yeah. So we need to put big question marks to these lawyers as well in the law schools. My last point is that families are important as well. Parents. Whatever I am today is because of the values my parents gave to me. So that was much later that I talked about human rights issues in university and BHR in year 2000. So I believe we as parents and others in family, they have a key role to create good citizens. Thank you.
Thank you, Surya. I do really like that last point about family values because we don't often think about that, how much family shapes who we become. So thanks for that comment. We have a question. We're running really now out of time. So we're almost done with questions though. We have a question from Fernando Morales de la Cruz about the German Supply Chain Act. I won't be able to probably pronounce its German version. He or she is asking, have you followed the false debate about the law? They did not even consider the views or opinions of the victims of rights holders. Many German and European NGOs pretended to represent the views or interests of the victims, even if they have partnerships with exploiters or are financed by beneficiaries of exploitation. So the question, there's no question really, but just kind of, do you have any reflections on the German law as well as this comment from Fernando?
Yeah. I think all these are interesting initiatives, whether they're taking place in the Netherlands, in Germany, these mandatory due diligence legislation in Norway in different shapes and sizes, or in the European Commission. These are exciting developments, perhaps going in the right direction, asserting the value of rights. That is what I'm suggesting. But I think, as I'm repeating again and again, if this European Union legislation, European Commission legislation is going to apply extraterritorially, then they need to consult not merely within Europe, they need to consult globally.
Yeah.
They need to consult the victims and the supply chain. How many in the global south are even aware of European Commission thinking of doing it, right? So I think that is the mindset we need to change. So they should, of course, listen to all stakeholders, including the rights holders in Germany, but they also need to think of the intended beneficiary of this legislation. And they are not in Europe, many of them. But are we asking these questions? Perhaps not. And that is what I'm trying to encourage all of us doing more of that. I mean, I enjoyed very much all the questions. I don't know if there are more questions left, but I very much enjoyed all the questions. And I hope that credit goes to Essex for inviting me to speak about this.
Thank you, Surya. We have one final, not a question, but a comment from Tara, and I just want to read that out loud because otherwise
I was wondering why Tara is not asking the question. Yeah, that was quite a puzzle. So here we go.
I wanted to give priority to our guests, but I won't not read her comment. So that's the last one left here. So she says, as we talk about the disconnect in Pillar 2, can I ask the UN working group really reflect on the language of cause, contribute, and directly linked to? The guidance to date has been centered on examples rather than principles or elements, watering down the right to remedy within Pillars 2 and 3. It re-emphasizes the notion that this is a social responsibility. Businesses get to decide for themselves as to how they'll fulfill it. So that's the comment, and a task maybe for the working group to take on.
Thank you, Tara. That's probably I will speak once I finish my mandate on the working group, which is going to happen in just over a year time. So I'll be happy to respond to your question after I finish my mandate. But I think it's a legitimate question to ask. Yeah. And I hope more people ask difficult questions to the working group so that the working group gets out of the comfort zone, in my view. Don't quote me on this, but yes, I believe that everyone has to be accountable.
Thank you, Surya. Sheldon, would you like to make some closing remarks? I'm going to actually close my camera so you two can wrap up the session. But I'll be here. I'll be here if needed.
He's throwing you on the mercy of someone who's technologically retarded. So, okay, but let me just say, this kind of comprehensive but highly well integrated set of comments, what I hope lead people listening to look at the business and human rights features as a whole, integrated. Each one needs the other, and no one is better placed to do that for us than Surya Deva. I think we all owe him a great thanks, and not just for what he has done, but what we enthusiastically look forward to what he will do. And thank you all for your questions that were very interesting and penetrating. And I just want to say, next time we carry on.
Thank you very much, Sheldon, and thank you everyone for listening and posing those very interesting and challenging questions. And let us keep in touch and continue to push the agenda. A rights-based agenda, let me put it this way.
Yes, agreed.
Thank you once again.
Thank you, Surya, for joining us. Thank you, Sheldon, for chairing the session. I'll now close the session. And thanks to our participants for listening. Bye, everyone.